That's the most underappreciated function that we serve for our members, but we are out there constantly. We cover over 100 local jurisdictions in our territory, which includes San Bernardino, Ventura, and Los Angeles County. And we also have 2 full-time Sacramento lobbyists, and we contribute to
Dan, we lost audio. Can you unmute again? Alt-A.
How's
Thank
that?
you. Perfect.
So I was saying we're very active lobbying and trying to get out there and protect people's property rights. There's a lot of concern among apartment owners these days. It seems like every time we turn around, there's a new regulation or ballot initiative being proposed that seem to make no sense and seem to slowly chip away at our investments and our property rights. So we're very active in that realm. So why don't you go to the next slide, Marta? Can you hear me? Next slide. There we go. Before I get into this, I just want to mention to everybody that everything you see here today is also on our website, which is at aagla.org. And Marta has a copy. She could send this to you. And as she said, she's going to be recording this session. So that'll be made available to you. So what we've seen lately in response to this coronavirus is we've seen a number of local jurisdictions passing temporary, and we hope only temporary, and we hope short-term temporary eviction moratoriums. On March 16th, Governor Newsom issued an executive order, and basically his executive order authorized local jurisdictions, should they choose, to place eviction moratoriums to help keep people housed that are impacted by the coronavirus. So we are getting a lot of questions, and we're getting inundated with phone calls from owners that are having tenants call them and saying they just don't want to pay rent. And there's a lot of confusion out there. Tenants just think it's basically they have free rein to just stop rent payments. And that's absolutely not true. The tenants that do not pay rent and would be subject to this eviction moratorium must be directly affected by the virus itself. They must experience a job loss or reduction of hours, or have substantial medical expenses, or have to care for a family member, or incurring childcare costs. And those things must be substantial. They must be experiencing a substantial financial detriment as a result of the COVID-19 coronavirus. They just can't say, I really don't feel like paying my rent, or I'm worried I may be losing my job in the future. It actually has to be related to the virus. And so there is a lot of confusion out there about that. And what we are telling our members, if they do have renters that claim they're being impacted by the virus, is to try to work something out, work out partial payments. This isn't the time to put people out on the street, particularly if they're truly being impacted by this catastrophe. A number of cities have already passed these ordinances. I put together this list just like on Thursday last week, and it's already expanded by a number of other additional cities. So this is only a partial list today, and we are going to be posting a complete list, in fact, a chart going over each of these local eviction moratoriums on our website pretty soon. And typically what they entail is, they typically remain in place until this crisis is over. Some have terms on them of 45, 60 days. And they typically require repayment once the crisis is over, generally over 6 months, which is what the governor had put in his emergency order. Irrespective of these local eviction moratoriums, the federal government is also looking at an eviction moratorium. At the same time, they're looking at a foreclosure moratorium. President Trump announced that last week, and says that he's instructed HUD to look at creating some type of legislation around that. And then locally I know this is happening in Santa Barbara County and also in LA County, courts just aren't hearing eviction cases. In LA County, they're continuing all the eviction cases until April 16th. So even without an eviction moratorium being in place, owners would not be able to evict renters until at least April 16th in the county of Los Angeles. So again, we are suggesting that you do your best to work things out. If you have clients in the multifamily housing industry, try to work things out the best you can. But if a renter is not paying their rent, or if you need to evict them for some other reason, and if the tenant is not paying their rent because of a reason that is not due to the coronavirus, then you can proceed with eviction proceedings as normal. We can go to the next slide then. So this is, I always like to talk about where we are today in terms of rent regulations, and they're continuing to expand. California is definitely in the minority of states. There's only 5 states out of 50 that have rent control and tenant protection regulations in place. In addition to that, we have the District of Columbia that have had these rent regulations in place for over 40 years, just like California has. And then there's 34 states in the United States that have no rent regulations whatsoever, and any type of rent control is prohibited under these states' constitutions. And you can see there's a number of states that I've colored in red, and these are states where renter groups are organizing and trying to push through rent control and tenant protection regulations. Massachusetts, many years ago, overturned their rent regulations, and they had a building boom that resulted. Now tenants are back trying to push the local city councils and the state legislature there in that state to provide rent control and tenant protections. And what we've seen in a number of cities here in California and throughout the United States is these renter rights groups are organizing, and they have a pretty strong message. Their message is the rent's too damn high. And what they've done is they've categorized virtually every city in the United States as either A, B, C, or D, and they're currently working off the A list and trying to put these different cities under rent regulations. Then there's 11 states in the United States that have no rent regulation, but there's no prohibition. And then there's a number of California cities, about 25 of them, that have rent control and eviction protections and a number of other tenant protection regulations. Now, I've been doing my job with the Apartment Association now for a little over 2 years. I'm a CPA by training, and this is actually my encore career, as I like to call it, my second career. And when I started a couple of years ago, there were only about 14 cities on this list. So you can see in just a couple of years, it's grown, and we are hearing more and more about threats of rent control coming in different cities, even in places where we would never have expected there to be rent control. And typical conservative bastion like Orange County, there's a couple cities there, Anaheim and Santa Ana, where tenant groups are organizing and they're pushing for rent control. So it's growing more and more. In addition to just rent control and some of the eviction protections we've seen a number of ordinances that provide relocation benefits to renters. And in some cases, like the city of Los Angeles, those could be pretty substantial. They're over $20,000 just to evict a 1-bedroom apartment. And then we're also seeing a growing trend of what we call TOPAs, which is a tenant right to purchase or rights of first refusal. And cities are forcing owners who want to sell their properties to either sell these properties to the government at some determined market value, or to a nonprofit organization, or even to the tenants themselves that live in the building. And we just saw an ordinance that was proposed in Oakland, unfortunately didn't pass, one in Berkeley, but there are a couple cities around the United States that have these rights of first refusal, and we're going to see more and more of them being proposed. We're seeing one now being proposed in the city of Los Angeles, and the city attorney's office there is trying to figure out if something like that is legal. You can go to the next slide. And Marta, feel free to stop me if you want me to take any questions at any time. I think you went past a couple. There we go, the housing study one. There you go, stop. All right, great. So a couple of years ago, back in 2018, there were a couple of housing studies done up in the Bay Area. The CASA Compact and the Turner Center for Housing Innovation both produced a couple of studies. And what they were trying to do is figure out ways to deal with the Bay Area's housing problems and the housing shortages and the fast rising rents. And so they got a bunch of stakeholders together, included people who work for local government, people that worked at apartment associations, tenant groups, and a number of other constituents. And they came up with a bunch of ideas. And some of the ideas were, let's have some rent caps. Let's have a rent cap of CPI plus 5%. We need to provide renters with rental assistance. Tenants facing eviction need access to attorneys, so let's pay for attorneys. But at the same time, we need to increase supply. So let's come up with a number of ways to encourage developers to build more housing, particularly affordable housing. And so if you go to the next slide. Next slide, please. Our state legislature read these studies, and what they did is they gave birth to Assembly Bill 1482, which is the statewide rent control and tenant protection law, and that became effective on January 1st this year. What this bill does is it provides for a rent cap on rental properties that are not subject to a more restrictive rent control. So properties in cities like Los Angeles and Santa Monica, San Francisco, Berkeley, and one of the 25 others, or 20 or 21 others, would not apply to those properties. But if they are not subject to those more restrictive rent control laws, it limits rent increases to the CPI, the change in the Consumer Price Index, plus 5%. That's roughly 8.34% for Ventura County and the state of California as a whole. And I'll get to a chart on that. It also requires owners that if they gave greater than a roughly 8.3% rent increase after March 15, 2019, it requires them to roll back their rents effective January 1st to be in compliance. It also imposes what's called just cause eviction protections to tenants. And so now if an owner wants to evict a tenant and they're covered by the Assembly Bill 1482, they can only evict their tenant for a reason that's stated in the law. And I'll go over that in detail in a little bit, but typically that's non-payment of rent, conducting criminal activity at the property, and a number of other things. And again, owners are exempt from this if they're under a more restrictive just cause eviction protection law in their local jurisdiction. So if you want to go to the next slide.
Daniel, we have one question, if you might take one.
Sure, absolutely.
Okay, so we had a question that was typed in and it said, if you have a lockout schedule as of 4/1, does it stand?
A lockout schedule. I wonder if they could explain.
Let me see if I can unmute them. Hold on. Okay, the person asking the question has, wait. I'm not able to unmute that person.
Okay.
Oh, they're unmuted now. Okay, you can ask the question.
I guess we had a eviction in progress and it was scheduled for a lockout on April 1st. And so
it sounds to me like
would that continue?
It sounds to me like it's already been adjudicated and you have your lockout scheduled. So it would seem like you are okay to go. The governor's order just became effective, and you already received a judgment on this renter. So, and I doubt the renter was claiming impacts of the coronavirus. So I'm sure you're good to go on that.
Thank you.
You bet. So the one thing I want to mention, though, I want to mention on 1482 is that the one thing we still have going for us as rental property owners is when our renters move out, we can raise our rents to market. The protections we have with vacancy decontrol under the Costa-Hawkins Rental Housing Act which was the battle we had back in November 2018 with Prop 10, are still the law and they still stand, but that's under threat, and I'll get to that a little bit later. I just want to warn everybody, as I mentioned, I was a CPA in my former life, and so I'm a recovering CPA, I'm not an attorney, and there's a lot of vague provisions in Assembly Bill 1482, so if you have legal issues or legal questions on these, it is always suggested that you consult with an attorney, and I just like to put in the Surgeon General warning into my presentation to make sure everyone's aware of that. Because of these vague provisions, we'll probably need a lot of interpretation through the courts over the next 5 to 10 years on Assembly Bill 1482. So if you want to go to the next slide, Marta. This is the Consumer Price Index. And again, the rent caps under Assembly Bill 1482 are the change in the Consumer Price Index plus 5%. This is an annual average of the Consumer Price Index measured from April 1st to April 1st, and it's produced by the Department of Labor. So we're still dealing with the April 1st, 2019 CPI. When April 1st, 2020 rolls around, it'll probably take a month or two for the Department of Labor to recalculate the CPI for the various regions in our state. And so up until the Department of Labor publishes its new CPI for Ventura County, for the greater LA area, it's roughly 8.3.4%, which is the rent cap, that maximum increase you have in Ventura County. So you can go to the next slide. I briefly mentioned before, there's a number of exemptions under Assembly Bill 1482. And again, there's two provisions, two real major components of Assembly Bill 1482. There's the just cause eviction protections, and then there's the rent cap or the rent control that was imposed under this new state law. Each of these could be applicable separately, or they could be applicable together, or you could be exempt from both. It just depends, what type of local ordinances you have in place. But for the just cause eviction rules, and again, these are about 10 or 11 rules placed into the state law that are reasons you can evict your tenant. If you don't have one of these reasons, for instance, if you just don't like your renter's personality, you can't evict them. That's not one of the reasons stated in the law. So you just have to be careful with that. This is something, we're used to dealing with this in Los Angeles County, but it's a new concept for you up in Ventura County because you don't really have these types of rent regulations in place. So again, if you are subject to a more restrictive just cause eviction ordinance locally, then Assembly Bill 1482's just cause eviction rules would not apply to you. Also, one of the things that we lobby pretty heavily for in creation of this bill is we got an exemption for the first 12 months of tenancy. We wanted at least 12 months to test drive our renters. We didn't want to get stuck with one of these professional tenants that like to come in, make your life miserable just to get a payout so you pay their relocation fees right away. So we got 12 months to test drive tenants before these just cause eviction provisions fall into place. And just a little nuance, if during the first 12 months, another person gets on the lease, another adult, then you get a 24-month exemption. So just beware of that. In terms of the rent caps, again, if you are under more restrictive rent control, the rent caps under Assembly Bill 1482 do not count. In the city of LA, the rent increases are typically between 3 or 4%, or 3 or 4%. So this wouldn't apply because this gives you 8.34%. However, it would apply to buildings that are exempt in the city of LA from the local ordinance. And in LA, the local ordinance was passed in early 1979. So under state law, any building constructed after the passage of the LA City ordinance would have normally been exempt from the LA City's rent control. Now Assembly Bill picks up those buildings up to between 1979 and 2005. Single-family homes are exempt from the rent caps. However, if the single-family home's owned by a corporation or an LLC that has a member that's a corporation, it's not exempt. So these apply to S corporate. Assembly Bill 1482 applies to S corporations that are that own single-family homes. So you have to be careful with that. It does not apply to homes, single-family homes that are being rented that are owned by a family trust. We were able to get that taken out of the law during our lobbying efforts. Owner-occupied duplexes. If owner lives in one half of a duplex as their primary residence, then that whole duplex is exempt from Assembly Bill 1482. And then newer construction for 15 years are exempt from Assembly Bill 1482's rent caps. Now that's a rolling 15 years. So anything built after 2005 is now exempt. Starting next year, anything built after 2006 will be exempt. Again, it's a rolling 15 years. You only get 15 years of exemption from these rent caps. You can go to the next slide. This is a slide I just like to point out that it's on our website, but you can kind of see that, again, there's really two major components of Assembly Bill 1482. One could apply to you and one may not, or vice versa. Both could apply to you and both you may be exempt from, so just be careful. And typically the driver is if you're under a more restrictive rent cap, then the rent limitations don't apply. And if you're under a more restrictive just cause eviction rule, then the just cause eviction rules don't apply to you. You can go to the next slide. So there's two kinds of just cause eviction rules under Assembly Bill 1482. There's at-fault just cause eviction and no-fault just cause eviction. At fault is where the tenant did something that results in your trying to evict them. So that's typical things you can imagine, like failure to pay rent, breach of a material lease term, conducting criminal activity, destroying the property, signing or subletting in violation of the lease terms, refusal to allow an owner to enter the premises after applicable notice, and a number of other things. So again, these are at-fault just cause evictions, and you are entitled to proceed to evict somebody for any of these reasons, but for no other reasons under Assembly Bill 1482. And you would not be required, because because your eviction is based on the tenant's fault, you would not be required to pay any type of relocation. You can go to the next slide. These are the no-fault just cause eviction rules under Assembly Bill 1482. This is where the tenant is not at fault. And if you evict a tenant because of a no-fault just cause eviction, then you would be required, assuming the tenant has been in the unit for more than 12 months, you'd be required to pay relocation fees equal to 1 month's rent. It's not that bad. It's not like in the city of LA or San Francisco where you're paying $20,000 or $30,000, to get somebody out for a no-fault eviction. But we believe it's only a matter of time before that amount increases to a couple months, 3 months, and eventually thousands of dollars, just like all the other local ordinances. So it's just something that we're going to be keeping our eye on. But one of the reasons you can evict a renter and get them out just by paying them 1 month of relocation fees is if you as an owner tend to occupy the property as your primary residence, or one of your family members intends to occupy. Another reason is Ellis Act, withdrawal of your property from the rental market. Ellis Act is a state law that actually allows rental property owners to go out of business when their business is failing. It always amazes me that California had to pass a law to allow owners to exit a failing business, but we've got one. It's called the Ellis Act. And one of the probably the most talked about, I won't say controversial, reasons is for a substantial remodel. Now, in order to evict somebody for a substantial remodel, and I have the definition right there, but in general, the work you're being done has to be much more than just cosmetic. It has to take 30 days or longer to complete the work. During those 30 days, there have to be unsafe conditions in the unit such that the renter cannot stay in the unit. And also you have to pull permits when you do the work. So that's the criteria for a substantial remodel. And I get a lot of discussion about that, owners trying to game the system and figure out how, you know, they could work under that definition to try to get a renter out and rehab a unit and then increase the rent when they'd like to. But you really have to be careful with that. What we're seeing is a number of local cities like Los Angeles and Glendale are implementing local ordinances to really tighten down on these provisions and forcing owners to get permits before they issue a notice of eviction and include with the notice of eviction copies of all permits, material or immaterial permits, along with a detailed explanation of the work that's going to be completed and substantiation for why it's going to take longer than 30 days, why the renter can't stay in the unit, and why there'll be unsafe conditions should the renter remain in the unit. So it's really pushing a huge burden on owners to fall under the substantial remodel definition in order to evict a renter under a no-fault eviction. You can go to the next slide. There's a couple of notice requirements that you need to be aware of. And if you're a member of the Apartment Association of Greater LA, we've already built in these notices. We have a one-page notice where you could provide this to your renters. And we also have this built into our new lease agreement. But for all new leases starting July 1st and existing leases starting August 1st, you need to notify renters if your property is exempt from Assembly Bill 1482. And by exempt, it would need to fall under one of the exemptions to be exempt. And we went over those obviously in a previous slide. If you go to the next one, same requirement by July 1st for new leases and August 1st for existing leases. If your property is subject to 1482, you need this disclosure in your lease, or you need to provide a notice to your renters that they are covered by Assembly Bill 1482. You can go to the next slide then. So I've pretty much gone over everything there is to, or at least what I wanted to present on Assembly Bill 1482. I figured it's a good stopping point. I want to get into some of the other new laws that got passed and then some of the laws that are being proposed for the current legislative season. But I wanted to stop and see if there are any questions people had on Assembly Bill 1482 or anything else that I talked about previously.
Okay, so I did have a question about getting the slides, and we will send those out to everybody who's online now, so that's not a problem. And does anyone else have a question for Daniel? You can use the raise your hand function on the toolbar at the bottom of your screen, or you can type it in and I can read it to him. So we'll take just a pause here and see if anybody has any questions right now.
I'll use some hand sanitizer while we're pausing.
I have a question. I don't see the hand raise feature thing though.
Okay, go ahead.
We have an owner who, he bought a property last year with a unit that had a very under market rent rate. And so in discussions with the tenant and the owner, we raised it 2 times gradually, but it was a hefty increase, more than a couple $100. She was totally in agreement to it though, because she knew that she was paying under market and she was okay with staying and paying. When the bill passed, we explained to everybody that on January 1st, it had to be corrected to the adjusted allowance per the bill. Now the owners have decided that they want to go ahead and substantially remodel the unit. And so they've given her a notice to vacate. They've even agreed that after remodeling it, she can move back in and she's going to pay this new rate, which she had already agreed to. But the owner is asking if she's in agreement to pay the new rent without them remodeling it, can they do that? Even though it's way above what the bill allows, if she's okay with staying as is without the remodel and paying the new amount, can he do that?
Well, there's a couple of things that come into play. My initial answer is absolutely no, but it depends on when these 2 increases came up initially. I mean, if they were after March 15th, 2019, then you do have to roll the rent back.
That's what I told him. The rent increases were in around like October.
Yeah. And then you have to follow the state law. So you've already given, you've already given the maximum increase you can for the year. So you cannot increase rent again, until the next year rolls around. You have to abide by the state limitations. And I'm assuming this is an older building, not built within the last 15 years. So it's not.
Right. Really old farmhouse from the 50s.
Yeah. And it's a single family home?
It's not. That's why
Okay.
It's a guest house in the back
Guest house in the back of a what?
of a single family. So it's
And
two dwellings on one property. Nothing is owner occupied.
Oh, okay, yeah, so that's considered a duplex.
Thank you.
You bet.
Okay, do we have any others? Okay, Daniel, let's proceed. Thank you.
All right. So right now we're under an emergency declaration. So if you have a rental property that is not subject to some local ordinance and not subject to the statewide rent control, you cannot increase rent by more than 10%. This is an anti-price gouging law, and it applies not only to supermarkets and gasoline, but it also applies to rental housing. So you just need to be aware of that. That even on a new rental where a renter has moved out and you are, your unit is decontrolled under vacancy decontrol law, you cannot really raise your rent by more than 10% to the new tenant. Now, if you find yourself in that situation, or one of your clients find yourselves in that situation, it's always best to consult with an attorney on that. I've gotten different opinions. What our general counsel here at the Apartment Association has told me is that, so if as a result of an emergency declaration, there's a greater demand on apartment housing and prices are rising because of that, then you would be subject to this 10% increase. We're not really seeing that right now as a result of this coronavirus, so the 10% limit may not be applicable in that situation. But I always encourage people to speak to their own attorneys about it, because I've had other attorneys weigh in and other attorneys feel it's a strict 10%. So just be careful of that. We had a couple of new bills regarding housing vouchers, one applicable to veterans and one applicable to Section 8 voucher holders. And these are anti-discrimination bills. It's anti-discrimination based on the source of income of these renters. And if you look on Craigslist today, you can probably see a lot of advertisements still where people have open apartment units and they state in their ads, no Section 8. Well, that's illegal now. It's illegal by state law, and these owners could get fined for doing that. What owners need to do is they need to give consideration to the Section 8 voucher holder as if it's part of their income, like their salary. And they need to evaluate them on that basis. So if rental property owners are getting phone calls asking if they accept Section 8, the correct answer is not saying no. The correct answer is you're welcome to submit an application. You're welcome to come by and see the property. We're seeing a lot of our members getting calls baiting them with these questions. Do you accept Section 8? And if they don't know, they give the wrong answer and they say no, and they're just inviting a lawsuit to come in. So you really need to be careful with that. And what we advise our members today is to make sure you have a written financial criteria that could include a certain amount of gross income. And again, you need to factor in the housing voucher as if it's part of gross income, have certain debt ratios, FICO or credit scores, but you need to have a documented criteria for accepting your renters. And if somebody comes with a Section 8 voucher and they meet that criteria, you have to give consideration to them, whether or not you want to participate in the administrative nightmare that sometimes comes with Section 8 housing. So again, you can't discriminate against a voucher holder. You need to be very careful with that. There's also limits now, effective this year, on security deposits that can be accepted for active military personnel. And that's limited to 1 month unless you're renting a furnished unit, and then you cannot accept more than 2 months of a security deposit from your active military personnel. What we're seeing, just as an aside, and there's a bill being proposed today in Sacramento where a state legislature, and this has been done in Ohio, wants to get rid of security deposits entirely. What they want is renters to have to procure insurance to cover the amount of the security deposit. And if there's damages to a unit, then the owner would have to go after the insurance company to seek repayment. And there is a bill going around Sacramento like that, as I said. They're concerned by our legislature here in California, and the one in Ohio is that when renters rent an apartment, they have to lay out too much cash with first month's rent, sometimes last month's rent, and then a security deposit. So they want to limit the cash outlay and the burden that tenants are receiving. Assembly Bill 1110. This requires a 90-day notice for any increase over 10%. Gone are the days of the 60-day notice. Now it is 90 days if it's between 10% and 15%. And then if it's more than 15%, you need a 120-day notice. And again, these would obviously be for rental units that are not subject to a local rent control ordinance or subject to statewide rent control. These would be the newer units or units that have some other type of exemption. You can go to the next slide, Marta. There are a number of bills that did not pass, fortunately. One was the so-called ban the box legislation, which would have prohibited property owners from asking about criminal background on their rental applications. What this bill's author wanted property owners to do was not be able to ask, but then figure it out later when they ran a credit check or criminal background check, kind of figure it out on your own, which obviously wasn't very fair. And we were glad this one barely made it out of, did not make it out of committee last year. The other one was rental registry. Many cities like Berkeley and San Francisco, Los Angeles, Santa Monica, even in Beverly Hills, all the typical criminals, as I like to say, have these rental registries where you need to disclose when your renter moved in, how many bedrooms, bathrooms the unit has, how much rent is being paid, when the last increase was, do you provide parking, do you pay for utilities, and a bunch of other confidential information that needs to be disclosed. And, for small property owners, it shouldn't be too big of a deal, except for the fact that you have to disclose a lot of personal financial information. But for owners that have hundreds, even thousands of units, it's a huge administrative burden. And I will tell you, for my 4-unit apartment building, because of some of the quirks on one of the city's websites, it literally took me an hour to put in my information. I've got a full-time job, and it's a real hassle to have to deal with that. This bill did not pass last year. However, it's back again this year. And so our association is going to oppose that. One of my favorite bills down there at the bottom is Senate Bill 529. Senator Durazo was a former union boss. And what she wanted to do is she wanted to allow renters, by merely submitting a written grievance to a property owner, to be able to go on a rent strike for up to 30 days. And fortunately, that one did not make it out of committee, and we lobbied pretty hard against that to defeat it. Haven't seen it back this year, but if it doesn't come back this year, I'm sure it'll be back next year or the year after that. That's why I have the Douglas MacArthur graphic up there, I shall return, because these guys just need ideas and they want to put bills out, so they keep on circulating same bad ideas over and over again in hopes that they stick someday. You can go to the next page. These are some of the other proposed new legislation for this year. As I mentioned, we got the rental registry back again. Woohoo! We're very excited about that. We also have Assembly Bill 2272. State of California wants to fund attorneys for tenants facing eviction. So it's pitting the state of California's budget against a property owner's budget. Highly unfair, but they're doing it. We have another bill proposed by the California Apartment Association, which we're supporting. This would increase the number of available units for people to rent. And what this allows is it allows the splitting of dwelling units. So taking 2 bedrooms, converting it to 2 1-bedrooms, or 3-bedroom into 2+1, or 3 1-bedroom units. And this would streamline the process and basically allow for ministerial approvals on that without any of the parking requirements. And we definitely support that one. Another bill would limit late fees to just $50. And sure, there's a lot of renters out there that are highly rent burdened, and this would definitely be beneficial to them and not very beneficial to owners. But what this typically does is this typically benefits wealthier renters that, you know, can afford to pay $3, $4, $5, sometimes, you know, in the case of Beverly Hills, $10,000 a month for rent, and they would have their late fees limited to $50. This one is very, very unfair to most property owners. And there's another bill, Assembly Bill 3077, which would prohibit an owner from evicting renters in anticipation of selling their property. And there's a lot of instances where that's important, where a seller would like to deliver a building vacant to the new owner so they can come in and rehab it. And this would now be prohibited. You can go to the next slide. A couple of more bills. There's a housing assistance fund being proposed, Senate Bill 1015, which we are supportive of. We always, anything that helps renters pay their rent, we are always very supportive of. So we are glad to see that one being proposed. Senate Bill 1079, this one grew out of the Moms for Housing, which you may have heard of, up in Oakland, where 3 moms and their children took over a single home that was vacant. It's now happening in the LA area. There were 12 Caltrans homes taken over by homeless families. What this would do is this would force a owner to sell their property to the state of California if it's left vacant for 90 days or more. And this applies to corporate owners who just are inventorying their properties and leaving them vacant. There's a Senate Bill 1340, which deals with the balcony inspection law passed last year. This is a bill that's being sponsored by our association. And what this does is it allows people doing the balcony inspections, professionals, contractors, engineers, doing the balcony inspections themselves to do the actual repair work. What we found with this balcony inspection bill, and I'll get into a little bit more detail on that later, what we found is it's nearly impossible to get inspections done because contractors weren't willing to put their licenses on the line to do the inspections if they couldn't do the actual work, the actual repair work. So we're moving this one forward, and we have a sponsor, Scott Wilk, in the Santa Clarita Valley, who's pushing this forward for us. You want to go to the next slide? All right, so I want to talk about a couple of ballot initiatives that you need to be aware of and you need to contribute to your political action committee over at your local association and over at CAR. We have Prop 10 version 2.0 called the Rental Affordability Act. And what this would do, it's very similar to 2018 Prop 10, but it would basically take away what's called vacancy decontrol, and it would control the pricing on units as they become vacant, even when they become vacant voluntarily. And it limits price increases to just 15% over a 3-year period when a unit becomes vacant. And the person who asked the question about the apartment owner that was way under market, that person would never be able to catch up if this ballot initiative were to pass. It also includes single-family homes and condominiums under rent control if more than 2 of those are owned, whether they're being rented or not. If you own 2 or more, either condominiums and or single-family homes, you rent the 3rd one, you would be subject to rent control. And it's already qualified for the ballot. It's the same sponsor, Michael Weinstein from the AIDS Healthcare Foundation, the anti-development tyrant and socialist, And so he's pushing this through. He's going to spend another $25 to $30 million like he did in 2018. So the real estate industry and the apartment industry, we need to get together on this, and we're going to need to raise another $80 million to $90 million to defeat this thing again. And we've already done some initial polling, and we're going to be launching a campaign probably around the July timeframe once we have a ballot number for this. But look out for it. Again, it's the Rental Affordability Act, and it's nothing more than statewide rent control. Hopefully you guys are, as real estate professionals, are aware of this one, split roll, which would basically take away Prop 13 protections on commercial property. And this is something that the apartment industry is going to be pushing back against, along with the Real Estate Association. And the reason we're concerned about it as apartment owners is we just think it's the camel peeking under the proverbial tent. And it's only a matter of time before somebody says, well, you know, those apartment owners that own 5 or more units, they're going out and financing their buildings with commercial loans. They should be considered commercial properties. And so we think it's only a matter of time, if this were to pass, that they're going to come after apartment buildings as well. So we cannot let this pass. This again would reassess commercial properties to current market values for purposes of property tax assessments. So if you can imagine the dry cleaners or the car wash that's owned their property for 30, 40 years, paid like nothing for it in today's dollars, their property taxes are going to go up substantially. They're going to have to pass that on to we, the consumers, and so our prices are going to go up, and we're going to be the ones ending up paying for this. It won't be the property owners necessarily. It's also going to hurt a lot of businesses like law firms and a number of others under triple net leases. You know, they're going to be looking for other places to conduct their business. It's not going to be in California if suddenly the pass-throughs they get for property taxes go up substantially. So this bill could be very, very problematic for California and for many of us in the real estate industry. So look out for this. I'm sure you're aware of it, and I'm sure CAR is putting out a lot of information about it. You can go to the next slide. We have the balcony inspection bill. This became law January 1st, 2019. So it's been in place a little over a year. What this requires is it requires all balconies, are actually what's considered a elevated exterior element, to be inspected every 5 years. And the first inspections need to be done by the end of 2025, by December 31st, or by January 1st, 2025, you have to complete these inspections. An elevated exterior element is any element of a building above 3 feet, built out of wood, that extends outside of the 4 walls of a building that's made for humans to walk on. So that includes a balcony, includes outside staircases, includes outside walkways, and a number of other building elements. And again, you have to have these inspected by January 1st, 2025, and every 5 years after that. A lot of cities have not yet caught up to this law. So what's suggested is when you get the inspection and any repairs, just keep the inspection report and any evidence of repairs, tucked away in your files, because at some point local jurisdictions, local code enforcement will be asking for this. And again, we are trying to fix the law so that the inspectors themselves can do the repair work, so there'll be more vendors willing to do the inspections. Right now, it's very challenging, and our association has a long list of only 3 vendors willing to do this, and we can make that available if anybody needs that. But it's very challenging to find people willing to do this work and that are qualified to do this work. And you can see the different contractor licenses that are required. Contractor holding an AB or C5 license are typically qualified. Building inspectors can do these inspections, and structural engineers as well can do these inspections. And then you can go to the next slide. This chart, I just like to show the magnitude of rent regulations and tenant protection regulations that we have here in the Southland. Typically these rent regulations involve some type of rent cap, just cause eviction rules, provide for relocation benefits. And then of course they provide for annual registry and fees that get paid because they force the owners to pay for their own regulation. So typically it's a per unit fee that gets assessed and paid so that we could have rent control boards and things like that, regulating these passive investments we've all made in rental real property. And then you could just flip through the rest of the chart, Marta. You go to the next one, and the next one, and the next one. So some other regulations that we're seeing, the city of LA, we had a high-rise fire in a residential building, and happens to be a building subject to rent control, and the city is going to force the building to retrofit. And we, of course, are very concerned about resident safety, and that's always a good idea, but there's absolutely no support being offered this building, and no tax breaks or any type of breaks being offered to the owner for what could easily be a $10 million retrofitting project. We have some local anti-discrimination ordinances based on source of income in city of LA and the county of Los Angeles, and you'll be seeing those crop up in other places. Basically, these just impose higher penalties and in some cases jail time for infractions. Yes, the city of LA wants to put rental housing providers in jail for this discrimination law. And so you're going to be seeing that more and more. More and more local cities are looking at rights to counsel. West Hollywood and the city of LA are currently looking at proposing ordinances for that. There's a lot of seismic retrofitting ordinances going around. I haven't really seen any in Ventura County, but there might be some. But these are typically very expensive projects, can cost anywhere from 40 to sometimes 6 figures, depending on how many parking spots you have that need to be retrofitted and need steel structuring around them. And in many cases, like in West Hollywood, there's no relief being offered to owners to help pay for these. And often owners who are under rent control get forced to sell their buildings because they can't afford to raise the money to do the work, nor is there any kind of return on investment for doing so. City of LA is looking at a vacancy tax. If owners leave their units vacant, they could be taxed several $1,000s a year for that. They're also looking at their own right of first refusal ordinance. When a building gets sold, they would like to buy it. They're also looking at eminent domaining a number of buildings. There was a big fight going on in the Chinatown section of LA over one apartment building that was coming off an affordable housing covenant, and the city just wanted to go in and take it over to keep it as affordable housing, but the owner did not want to sell it to the city, so a big fight ensued. Some cities are looking at imposing 1-year minimum lease requirements. West Hollywood actually proposed that, and fortunately did not push that through. I'd mentioned security deposits being prohibited, and you're going to be seeing that more and more in the future. Berkeley just had a big fight on its right of first refusal. And then Washington State just passed a couple of laws. They are prohibiting evictions during cold winter months, irrespective of the reason for the eviction. So it could be non-payment, breach of lease, conducting criminal activity. You need to keep those renters in place if it's during the cold winter months. They also have this new first in line law that if you get 2 or more qualified tenant applicants that meet your rental criteria, you have no choice. You have to accept the first one. So with that, you can go to the next slide, Marta. So I'm very happy to take questions. My email address is on here. If you email me with any questions, I'll always answer you. I'm always happy to hear from people and help them out. What I really want to impress on people, and you guys are professional real estate people, is that when you're dealing with apartment owners, you could see, just going through my presentation, it's very complicated. There's a lot of rules and regulations, and they're constantly changing, and they're very, very complicated. And as I like to say, you can no longer make a passive investment like my parents and my grandparents did in apartment buildings and expect to operate successfully and operate without taking on significant liability without having help. And you either need to have gone to law school or been practicing in real estate for many years, or you need to be a member of an apartment association. And that could be any apartment association, whether it's ours or or any other, but these owners need to join some kind of an association to stay up to speed on the latest laws. And when they have questions, have a place to go to get answers to those questions, and also have the most up-to-date legal forms that they need to operate successfully. So I encourage all of you, as you have your dealings with apartment owners, to please encourage them to join an apartment association. We're here to serve them. For the price of literally a dinner on a Saturday night, you could get your clients can get a 1-year membership in an association like ours and get a lot of great benefits out of it. So I just wanted to leave you with that before I take questions. So I'm happy to answer any questions people have.
Okay, I don't have any written questions, but if there are some questions, just unmute your mic and we'll try to take them one at a time.
I think I put everybody to sleep, Marta.
No, they're still all here for sure.
They're probably shocked.
All right. Do we have anybody? I don't see anybody typing or unmuting. So with that, we'll close it out. And the recording will be available online here probably later today or tomorrow. And we will send out, oh, I have a couple questions coming in. Okay. And we'll send it out to all the participants, the PowerPoint. Though I have all good here. This was very helpful, and thank you for the information. So very good. Thanks, guys. Thanks for spending the morning with us. And Daniel, thank you for reaching out to our association and providing this.
It was my pleasure. Thank you. Anytime.
Thank you. Bye.